Good afternoon, everyone. We are thrilled to be presenting a timely webinar entitled Good Hair, Bad Hair, a discussion about the Crowns Act and discrimination, sponsored by the ABA's Section of Civil Rights and Social Justice and Young Lawyers Division. This panel is one of many in a series of rapid response seminars. We are actively planning additional programming on various issues. So please visit americanbar.org/CRSJ for updates on these programs. Today's program, we encourage you to ask questions of our panelists through the Q&A and not the chat function. If you do not see the controls, please ensure your screen is not idle. We will address questions at the end of the program. We will be sharing the recording of this program with everyone who has registered so they could share it widely with your networks. And with that, we are thrilled to bring you today's program, again entitled Good Hair, Bad Hair, a discussion about the Crowns Act and discrimination. Today's panelists are Aubrey Connor, Dr. Wendy Green, and of course, my name is Keisha Turner Roberts. This is a really personal and a timely topic. And as I was thinking about how to start this discussion, I'm really into poetry. And so I was looking for a poem that I thought that may encapsulate, I think, what this discussion is going to be about. And so I actually found something, and it's called Ode to My Hair, by Dean Mean. It is my style, it is my self-expression. It is rooted in my history. It is the connection to my ancestry. It speaks for me. It is the tenets of my collective story. It defines me. It's the liberation of my identity. It changes me. It's the expression of my ideologically. It classifies me. It evolves of my destiny. I am my hair. My hair is undisputedly me. So, with the recent passing of the Crowns Act, known as the Creating a Respectful and Open World for Natural Hair Act of 2022 in the House of Representatives, this bill is taking another step towards banning race-based hair discrimination at work, federal programs, and public accommodations. Currently, this act is heading towards a vote in the Senate, hopefully to be determined later this year. This historical congressional action comes after many years of advocates, such as the ladies on this panel, pushing policies to change at a national and state level. So let me introduce you guys to our distinguished panelists. Dr. Wendy Green. Professor Wendy Green is a trailblazing U.S. anti-discrimination law scholar, teacher, and advocate who has devoted her a good portion of her professional life's work to advancing racial, color, and gender equity in workplaces and beyond. Now, Dr. Green is the first tenured African-American woman law professor at Drexel University Klein School of Law. She's written in Teen Vogue, This Is News, and BBC News have celebrated Dr. Green for her pioneering role in increasing public awareness around, as well as securing legal remedies for what she has coined grooming code discrimination. From serving as a legal advisor and expert in civil rights cases, challenging race-based natural hair discrimination, co-drafting and drafting and advising rather on nearly 20 pieces of civil rights legislation, including the federal and the California Crowns Act, testifying in support of this legislation across the nation, delivering public lectures around the world, to publishing seminal legal scholarship. Dr. Green's advocacy has informed every key legal pronouncement throughout the United States that discrimination African Americans systematically encounter on a basis of their hairstyles is racial discrimination. One of the world's leading experts on this global civil rights issue and the founder of the hashtag Free the Hair movement, she is currently writing her first book #FreeTheHair, locking Black hair into two civil rights movements under contract with University of California, Berkeley Press. Our next panelist is Aubrey Connor. Aubrey Connor leads the Law Foundation of Silicon Valley's litigation and advocacy regarding health equity and the social determinants of health that impacts historically excluded communities across the Silicon Valley. Aubrey sits on the Law Foundation's Race, Equity, and Inclusion steering committees and leads work regarding jail conditions, encampment sweeps, and alternatives to involuntary medical and psychiatric treatments for individuals in Santa Clara County. She also, now she does this too, she also teaches educational law at the University of California at Davis. Prior to joining the Law Foundation, Aubrey was a staff attorney with the ACLU Foundation of Northern California, where she advocated for civil rights and liberties of Central Valley and Northern California residents, including several cases regarding natural hair discrimination in schools and advocacy regarding discrimination of Black hair products in stores. She also co-authored, in her spare time, she also co-authored the HOD 100B, which is the ABA's resolution regarding support of the Crowns Act. She serves as the elected Assembly Speaker for the American Bar Association's Young Lawyers Division. She's the Chief Policy Officer for that division and is appointed a member of the ABA's Children's Rights Litigation Working Group. And now we're going to play a video for everyone to see, so to get a taste of the type of what is going to help ground the discussion for today.
As Black women, we've already policed our bodies so much in these spaces. We still have these unwritten rules and policies that exist to the detriment of people who don't fit the status quo. I've never seen a policy that clearly articulated what I could and could not do with my hair. But I have seen the reaction, and I have felt the negative response of wearing my hair a certain way.
I'm just retouching up or retightening her locks.
My hair is in locs right now. I've been wearing it in locs for about 2 years. And before this, I was wearing twists. I went natural about 4 years ago. I decided to go natural because I had just gotten to a place where I was kind of done chemically straightening my hair. I have felt discouragement from wearing natural hair. There were concerns about, if you go to an interview with braids or locks or twists, whether or not someone would see that as something that's problematic or say that you don't quite fit the firm culture, things of that nature, that those hairstyles would impede you from getting jobs, would keep you from getting on big cases, would keep you from getting access to clients.
There have definitely been moments that I've had to stop to think about it, stop and think about what someone was saying and what it really meant. One example is just I went to this event with very straight hair, and I remember this particular person saying to me, your hair looks really nice like that. And those two words, like that, really, really sat on my heart for a really long time, because what it meant for me is that all the other times he would have seen me, interacted with me, it would have been my hair in its natural form, the way that I like to wear it, the way that I feel confident and proud. He never commented on my hair when it was in its natural form. And so I thought about that, and I wondered, who else thinks that my hair in its natural form is not the best way, or who else thinks it looks better like that?
As a Black woman working in the law, I'm always conscious of the underlying thoughts about what it means to have natural hair, about the fact that not everybody understands it. I am wearing my hair natural in my firm photo. That was a really intentional choice on my part, because that is how I wear my hair on a daily basis. And so I wanted basically my online presence to reflect how I am in real life.
I recall one time when I went to court, and I remember that morning just feeling so anxious. And not necessarily about the case. I thought we had a slam dunk case, frankly. Like, I did the analysis, I did the legal arguments. That was fine. But I was terrified about showing up in a way other than like absolutely muted. I was terrified that I would stand out by virtue of just like being Black, being a Black woman, having a certain cadence. I was just terrified of my Blackness or my natural hairness getting in the way of advocating on behalf of my client.
I think firms need to make sure that they are safe spaces for young Black attorneys and young Black women attorneys in particular to be themselves. And I think ensuring that hair discrimination doesn't occur is a component of that.
My firm supported me in working on the Crown Act. The Crown Act is legislation that makes it illegal to discriminate against people for wearing natural hairstyles in workplaces and in schools. From the legal perspective, what we did is go in and define race to include traits that are historically associated with race, including hair texture and certain protective hairstyles like locks, braids, and twists. So it really makes it very clear that hair discrimination is race discrimination.
I think it all really comes down to young Black women feeling and being supported in their careers. The biggest challenge for me, and I think that's probably a struggle for a lot of young Black women, because when they look ahead or look, up to, what's happening at the higher levels of law firms and in other organizations, they don't see anyone that looks like them. So it's almost like, is it really possible? Do people like me actually get to these places?
Okay, so let's get into it. So I'm going to start asking questions of my panelists. And as you can see, as everyone can see, all three of us are having different versions of natural hair. So I saw that to be very interesting and something I wanted to point out. So the first question I'm going to ask, and I'm going to ask both of you this question, is what are the challenges that Black women experience daily because of hair discrimination?
No, Aubrey, go ahead. Go ahead.
It's so funny. We're both like, okay, who should go first? Well, I just wanted to first start by saying I'm so appreciative to be here. My name is Abreu, she, her pronouns. And I think that some of the challenges that Black women face because of hair discrimination, like some of the things that we have to think about is just how are we going to present every single day, as the video kind of outlined, right? Like even in the mornings, are we going to go through all of these different routines in order to have our hair look a certain way for us to be in a meeting, or, to show up in a certain way, even on Zoom? I think about the pandemic and how a lot of people were like, oh, I don't really have to do as much to my hair. But I feel like for Black women, what I've heard kind of anecdotally, and I even think about this myself, is, well, there's still a level of, do I have to present in a certain way on Zoom, on camera? And these types of things impact just kind of, your mental exhaustion, the amount of time that you can dedicate to your cases, dedicate to your work. And then also when it comes to applying for different jobs, like if people are applying for jobs, the same way that we think about intersectionality with race and color, we also have to include hair in those conversations as well. Is someone with, a different type, a certain type of hairstyle going to be more likely to move first past the first interview for employment? And if I'm wearing my hair curly, bigger, is that going to present as a certain type of person who would wear their hair that way, even though it's the way that it naturally grows out of my head? And so I think that those are some of the things, the questions that you get about your hair as well. Typically, sometimes they come from an uninformed place, and that makes sense, but it's just the exhaustion of having to answer questions about who you are as a Black woman in a way that many other people don't necessarily have to answer to on a daily.
Professor Green, do you want to add?
No, Aubrey did a wonderful job in really illuminating all of the kinds of deliberations that Black women especially have to encounter or are encountering as we are navigating our professional decisions and choices and opportunities. And, one of those things that she mentioned, just having to think about whether or not you should straighten your hair or to have to use chemical straighteners or relaxants that can be really toxic to our hair shaft and to our scalps, and also the time and energy that it takes to have to conform to what I call a straight hair expectation and mandate, right? And the money. We are spending so much money, much more money, according to the Perception Institute, in terms of trying to conform to the straight hair expectations and pressures and mandates that we are encountering in our professional spaces. So these are also additional sort of burdens, if you will, these invisible burdens that Black women are having to navigate in order to feel at least at minimum feel as if they will be fully included, or at least more equally possibly included, and a feeling of belonging in these workplaces. But again, Aubrey did a wonderful job in really illuminating and highlighting the different, how we're navigating all of these different pressures and expectations to conform to Eurocentric norms of professionalism, of attractiveness, of beauty, what is considered to be right or acceptable in these workplaces.
Right. And when does this type of racism come up? You did mention the workplace. The other places that this type of discrimination can pop up?
Unfortunately, absolutely. Unfortunately, it is happening in other spaces beyond the workplace. As we know, Black boys and girls are being suspended and expelled from schools. They are suffering heightened levels of discipline when they're being dress coded, and oftentimes dress coded off the basis of even neutral policies, not even express policies that bar natural hairstyles like locks and braids and twists. But for example, like in the cases of DeAndre Arnold and his cousin Kaden Bradford in Texas, there is a so-called neutral policy that bars male students from wearing shoulder-length hair or having the propensity to have shoulder-length hair. And via the enforcement of that neutral, say, length policy, the boys were told that they couldn't grow their hair long. They're wearing their hair locked, and that they would have to essentially cut off their locks, this very fundamental part of their cultural and racial identities, in order to matriculate in their high school, in order to graduate and walk in graduation, or even to attend prom, as well as to participate in extracurricular activities like the band. We also have sisters in Massachusetts who were told that they had to remove their braided hairstyles if they wanted to participate in extracurricular activities, and were likewise are suffering discipline and in-school suspension for wearing their natural hair in braided hairstyles because they were perceived to be unnatural, is the irony of that. Also, outside of the educational context, we see that individuals have even been excluded from jury selection, from being able to serve in their civic duty as jurors on the basis of wearing locked or braided hairstyles. And people likewise have been barred from public accommodations like restaurants and bars because their locked hairstyles or braided hairstyles have presumably violated the organization's their grooming policy. So unfortunately, this is happening in so many different spaces in American life, but it's also happening globally. This is not something that is indigenous. This kind of racial discrimination is not indigenous to the United States. It is happening globally as we speak.
Aubrey, is there any basis for the notion that school behavior or school discipline is tied to, how one wears one's hairstyle or a particular style? Can you speak on that?
Yeah, so I definitely did a lot of cases around school dress codes for that reason. It's super outdated. You would think that in 2022 that most schools would really be focusing on the students' ability to just matriculate through school and have a safe and welcoming environment. But a lot of school districts continue to have really restrictive dress codes, and oftentimes it has to do with hair as well. There will be really broad language such as distracting, or as Professor Green also talked about, like long hair. One of the cases that I worked on out here in California was that very same issue. There was a student who had like longer hair. He had an afro, and the school basically stated that in order for him to graduate, he was going to have to cut his afro. And even though there was an exemption for, there was some type of cultural exemption, the school district actually stated that Black hairstyles didn't fit within that cultural exemption. And so you even see in school districts where they have particularly stated, like, well, we're trying to be welcoming of all individuals, that they still can find a way to try to exclude Black people from those conversations, which makes the conversation around the Crown Act so very important to really kind of hone in on how this shows up for Black students, how it shows up for Black people in particular. And oftentimes with dress codes as well, like I stated, they'll say things like distracting or exotic hair, and these vague terms, even in addition to the protections with the Crown Act, also are unconstitutional because they're vague, they're left to a lot of discretion. And what you see within the education context specifically, and quite frankly, in a lot of other contexts as well, is when you have this kind of language that can be interpreted a lot of different ways, it's typically interpreted against the communities that are historically excluded, and Black people in particular.
Yes, before let's talk about litigation. And before the Crown Act, how did you litigate these types of cases? I start on the state level, Aubrey. How did you do on the state level?
Yeah, so well, with the state and kind of federal, and I know Professor Green also has thoughts about this as well, is there you always have a First Amendment right to freedom of expression and freedom of speech. And so wearing your hair, in a way that expresses your freedom of speech, your freedom of expression, that is something that has always been protected under the First Amendment. And you do have that constitutional protection for that. The problem is that unfortunately, even though that protection existed, just like many other things that exist within our Constitution, they didn't apply as closely as they should have for Black people. You have equal protection, the Equal Protection Clause under the 14th Amendment as well, that also existed. And so if you're saying to just this group of people, well, you have to do something differently to your hair, or you have to cut your hair, and you're not saying that to anyone else, then that is a way for litigators, for lawyers to also approach this issue. Within different states, there can also be potentially broader protections. In California, California tends to have broader protections for a lot of race-based discrimination under like the Unrest Civil Rights Act, and then our state freedom of speech section within our California Constitution. So you would use those. And then in the education space, your state may have an education code that also has those protections. And so the education code within California also really is supposed to create a safe and welcoming environment for students. And so if the teachers or if the administration are doing things that kind of make it so that it's hard for the student to have that welcoming environment, targeting them, for example, as it relates to their hair, as it relates to how they're wearing their hair, saying like they need to cut their hair. I had a student that actually happened to once. Their teacher, it was a 7th grade student, told them that they could not return unless they shaved their, it was just like a regular haircut, and it was considered distracting. And imagine a teacher saying that to a 7th grader, and how this little Black boy now felt about his hair. But the California Constitution, California Education Code also allowed for there to be protections around this issue.
Professor Green, what about if I wanted on the employment side with employment discrimination? Can you speak to that, what's been done prior to the Decline Act?
Sure. So just to kind of piggyback on Aubrey's comment about the First Amendment being used in these cases challenging natural hair discrimination in schools, I'm happy to report that there has been a little movement, and actually groundbreaking movement in this space over the past couple of years. In the case involving DeAndre Arnold and his cousin Caden Bradford, I'm serving as an expert witness in that case that's being brought on by the NAACP Legal Defense Fund. And the federal district court judge in that case actually enjoined the enforcement of that grooming policy that barred male students from wearing long hair or having the propensity to have hair touching their shoulders. And in doing so, one of the arguments that the plaintiffs have advanced is that this essentially effectively forcing them to cut off their hair is an infringement upon their First Amendment right to cultural expression, and namely as African descendant or Black, and in Caden Bradford's case as being a Trinidadian American or of Trinidadian descent or ancestry. And so in this case, the federal district court did actually acknowledge that they did have an actionable First Amendment claim, and that this grooming policy might be infringing upon their constitutional right to a freedom of expression under the First Amendment. And additionally, the court also did recognize an actionable claim of sex discrimination under the 14th Amendment, as well as race discrimination under the 14th Amendment in light of the disproportionate enforcement, or at least the evidence of disproportionate enforcement at this stage of litigation. So this is actually a really groundbreaking, and to Aubrey's point is that it's been very challenging, obviously, to try to combat this kind of racial discrimination and infringement upon cultural expression via the courts. And namely, as it relates to things on the employment side, we have had numerous federal civil rights cases challenging natural hair discrimination as a form of race and gender discrimination under our federal civil rights statutes, like Title VII of the 1964 Civil Rights Act or Section 1981 of the 1866 Civil Rights Act for over the past 40 years. And unfortunately, what has happened in the federal space is that the federal courts have created what I call a hair-splitting legal distinction, which basically means that the courts have, many of the courts have thought about racial discrimination being limited to discrimination on the basis of immutable characteristics, or characteristics that you're born with, characteristics that are difficult to change, or characteristics that you simply cannot change, or in more recent cases, characteristics that only one particular racial group can possess, which we know there is no such thing. But what has happened, and that's why I call this immutability doctrine a legal fiction, but applying this legal fiction, what federal courts have said in these Title VII race discrimination cases where African descendant women and men have been challenging discrimination on the basis of afros, locks, braids, and twists, is that when an employer denies an African descendant worker an employment opportunity on the basis of their afro, then that is unlawful race discrimination in violation of our federal civil rights laws. But if that same person locks, braids, or twists that afro and then is discriminated on those grounds, then magically it has nothing to do with race. And it does not amount to unlawful race discrimination, and therefore employers are free to discriminate against African descendants who are wearing locks, braids, and twists, but cannot discriminate on the basis of afros. And so this is why I call it a hair-splitting legal distinction. And much that the courts have really been thinking of afros as something that is unique to African descendants, or that only African descendants can wear or rock, which we know know is not true. But nonetheless, not recognizing how these hairstyles, these natural hairstyles, have been very much associated with our racial identities and as markers of our African ancestry or our Black identity, and has served as a basis of longstanding racial discrimination and exclusion, not only in workplaces, but also in other spaces. And this is why the Crown Act is really quite important, because it helps to cure this gap in civil rights protections as it relates to discrimination on the basis of our natural hairstyles.
Right. Do you know how many municipalities have adopted the Crown Act or some similar type of act that does the same thing? Do you know?
Sure. So far, we have 14 states that have enacted the Crown Acts or parallel civil rights legislation that expressly treats natural hair discrimination as race discrimination. We also have over 30 municipalities that have adopted similar types of legislation, if not denominated Crown Acts. And then also we have very key enforcement guidance from enforcement agencies or human rights agencies like the New York City Commission on Human Rights, that has also effectively declared that natural hair discrimination that African descendants, as well as other people of color, experience in workplaces, schools, public accommodations, and housing constitutes unlawful race discrimination under their local civil rights statutes. So there's lots of movements on so many different levels administratively, in terms of administrative agencies or human rights agencies, as well as on the federal, state, and municipal level in terms of legislation.
Right. So what are the harms of race-based hair discrimination? I think you covered that a little bit, but if you could, is there psychological impacts? And if so, what are the impacts? Professor Green.
Sure. Well, obviously, we're seeing that there's lots of equal employment opportunities, educational opportunities. When we're talking about the employment sector, people have been deprived employment opportunities at the outset in hiring, as well as being harassed in workplaces. For example, we have an African-American woman in North Carolina who alleged that a petition had been circulated around her workplace for people to sign if they thought that her natural hairstyle was unprofessional. And unfortunately, the federal district court in that case did not see that type of petition, that kind of harassment, that kind of hostile work environment as being a violation of our federal civil rights law, and namely Title VII, because again, very narrow interpretations of what constitutes racial discrimination in our workplaces. Additionally, as you can imagine, when you're being stigmatized, when you're being harassed, when you're being policed, or what I call being subject to the hyperregulation of your body vis-a-vis your hair, there are going to be some serious emotional distress and psychological distress that many of these plaintiffs in these cases have discussed and alleged in their complaints. Additionally, oftentimes when we're talking about natural hair discrimination or prohibitions against natural hairstyles in workplaces, especially as it relates to African descendant women and girls, we don't really sometimes think about the fact that basically tells Black women and girls that you have to either cut off your hair, which is meaning extinguishing a very fundamental part of who you are, or you're going to have to either cover your hair or have to chemically straighten or engage in some kind of straightening of your hair in order to be included in these spaces. And what does that really mean? Well, for many of us, that means engaging in really toxic chemical relaxants that can lead to severe burns and hair and scalp damage, temporary and permanent in nature. There have been reports that there's a potential correlation between long-term use of chemical relaxants as well as hair straightening agents or products to maintain straightened hairstyles to uterine fibroids and higher rates of uterine fibroids and uterine cancer amongst Black women. And also reports that maybe that use of these chemical relaxants for Black girls can lead to higher rates of hormonal activity. And so these things, again, it's about the invisible harms. I often talk about the invisible harms of these bans and this kind of discrimination. It's not just about us losing our jobs, which is really important in our economic security, obviously, but oftentimes these types of bans leave us in these catch-22s in terms of pursuing educational and employment opportunities at the risk of our emotional, financial, and economic, psychological, and even physiological health. Or well-being. And so I often say, if you care about Black women's health, then you have to care about our hair.
I agree with that. And I also I think a lot about my clients who are in the Central Valley, And so a lot of the school districts there, the number of Black students was typically, at each school district, maybe less than 2% of the student population were Black. And so for those Black students, when they were faced with hair discrimination at those schools, not only are they already in a space where there's not that many of them, but then they're questioning everything about themselves at very formative years of their lives by people who are supposed to be there to protect them, by people who are there to be, their guiding kind of figures through those times in their life. And I even think about some of my clients who would state to me, it would, like, obviously as a Black woman, they would ask me, is how I'm wearing my hair wrong? Like, is there something wrong with what I'm doing? And just not even having that reinforcement in the educational space and having to kind of hear it from an outside party would oftentimes just break my heart. Like the fact that you have young people who are questioning, to Professor Green's point, like, who they actually are at such an early age. And in order for us to kind of change the narrative, like the Crown Act is so important. It's important for adults, but also, by the time we're adults, a lot of us have already endured so much trauma from the environments that we're in. And if we can stop that, or at least try to slow down like those kinds of conversations that are so harmful at such an early age, I think that those are the things that we should also be focusing on, because when you become an adult, you'll have a different framework about how you do yourself, how you present yourself as being confident, not having to second guess yourself, as even the video said, about whether or not you should show up to court with your natural hair or not, because it's already been ingrained in you at an early age that not only is that acceptable, but it is who you should be. You should present however you want to present as a Black boy or as a Black girl, and not have to question whether or not you should, be getting school discipline for literally just being who you are. And so those are some of the conversations even that come to mind whenever I was litigating and doing advocacy with young people as it relates to these issues.
Right. So let's turn to the ABA's involvement in advancing the Crown Act and other similar acts. Aubrey, can you speak to that since you are the person created the policy? Can you talk about that for us?
Yeah, so the ABA, and for those who may not know, in addition to like the different kinds of policy conversations that are happening all across the country as it relates to the Crown Act, the ABA can also adopt policies, basically urging for there to be different decisions that are made around a host of different issues. And sometimes when the ABA adopts those policies, it can be helpful. For example, if there's a novel issue that comes up in court. So sometimes lawyers will use those policies and say, well, the ABA actually, thinks that this is a good idea, or that we should move forward in this way. A lot of folks, at least probably within the last week or so, have heard a lot about the ABA and how they evaluated our Supreme Court nominee. And so these kinds of conversations percolate in other spaces as well. And one is the Crown Act. And so the way that the process works is that you can draft a resolution and then try to move it through different sections and divisions, and then it ends up at the House of Delegates. And so I co-authored the Crown Act on behalf of the ABA. And so it went to the House of Delegates, and our resolution supported the interpretation of race as it is included in anti-discrimination statutes, and not be limited to the color of one's skin, but also include physical and cultural characteristics associated with race, which is the kind of crux of the Crown Act. But we also urged the federal, state, local, and territorial and tribal governments to enact legislation banning race discrimination on the basis of texture, style, and appearance of a person's hair. And so not only were we having the conversations about what needs to happen federally, but as we've been discussing today, and as you heard in the video, and as you heard from Professor Green as well, these conversations have to happen not only at a national level, but also at a local level as well, in order for there to be true traction. And then we also encourage from the federal level down to the local level for there to be careful review of discrimination policies, and to also provide implicit bias training to eradicate discrimination on the basis of texture, style, and appearance of a person's hair. So that's really to help recognize that a lot of these conversations and a lot of the policies that existed did not necessarily have the Crown Act or have these types of issues at the forefront of the mind of individuals. And in order for us to start shifting that framework, we have to have those conversations regularly and consistently, and make it and normalize it, quite frankly, so that it's not taboo when it's brought up in the workplace, when it's brought up in the school system, when it's brought up in housing conversations, for example. And then we supported the enactment of the Crown Act and any other similar legislation that advanced anti-discrimination on the basis of texture, style, and appearance of a person's hair. And so it first went through the Young Lawyers Division, which is the division I'm the chief policy officer for. It passed unanimously, and then went to the House of Delegates and was adopted in the House of Delegates as well. And since then, the ABA has been very supportive of these kinds of conversations, of pushing the conversation forward. And again, as I mentioned earlier, I'm so appreciative of the ABA even having this conversation in the first place about hair, texture, styles, things like that, that quite frankly, hasn't necessarily always been a part of the ABA types of conversation, but it demonstrates the level of recognition, the support of really trying to incorporate this into a legal space, and why we need to continue to have these conversations at a level that anyone, no matter if you're a lawyer, no matter if you're not, can understand the implications of what this means moving forward.
Great. And how can these attendees become more involved? What recommendations can you make? They feel passion. How can they get involved in advocating for these types of acts? Either one of you can answer that question. Doesn't matter.
Sure. Well, as you mentioned before, the Federal Crown Act just passed the United States House of Representatives again for a second time, just a couple, not even barely 2 weeks ago now. And I'm happy to say it happened on my birthday. So it was a wonderful birthday present from the House of Representatives, and especially having the privilege to help craft that legislation. So I have to say it was a really wonderful birthday present and a wonderful birthday surprise. But that being said, there's still more work to be done, right? It has to be passed, is already introduced in the Senate, but it needs to be passed by the Senate in order for President Biden to sign it into law. And so one of the ways, an easy way for people to get involved, is contacting your United States Senator, as well as other representatives on the federal, state, and local levels, advancing the passage of this really instrumental federal civil rights law. Is additionally, if it has not yet been introduced or is in the process of the legislative process on the state or local level, whether it's in your city or in your state, also offering your support. You can do that by writing a letter or an email, or even volunteering to testify on behalf or in support of, calling in support of this legislation during these legislative hearings. It's really quite important for the legislature to understand that this is a real and systemic issue that not only African descendants, but people of color more generally are experiencing in all different aspects of their lives, as we've already illuminated. Additionally, I think having conversations like the very one that we're having right now, and that the ABA is also advancing and encouraging in this really, again, groundbreaking resolution that Aubrey, thank you so much for your leadership on this as well, because it is quite historic for the ABA to adopt this resolution. So we don't want to really underestimate the real significance, historical significance of this resolution. But having these conversations as we are trying to increase and really not only just increase, but be committed to actualizing our commitment to diversity, inclusion, and equity, and full belonging, and full dignity and respect being afforded to people's personhoods. I believe that having these conversations around the Crown Act, around similar types of legislation and legal reforms, as well as even changing policy reforms within our organization to affirm and celebrate our cultural expressions, I think are really very much in alignment with supporting this legislation, as well as other types of legal reforms. So educating yourself, educating others through not only this public fora, but even through private conversations. And much of this, I will have to say, frankly, happens at home. Is having these conversations, even in our personal spaces, that will bring about the kind of personal change that, in effect, will bring about the social, legal, political change that we want to see in the world.
I 100% agree with all of that. And I also think about, even when we think about our DEI groups, so I know a lot of firms, a lot of organizations are now trying to have groups within their organizations to think about DE&I. Consider, having this a part of it, as Professor Green stated, like actually affirmatively stating that, because what if we don't actually state it when we're talking about what DE&I efforts look like, then it could get overlooked, right? Also, if you're an advocate, if you're an organizer, one of the things that I do, for example, a lot of my advocacy is with unhoused individuals. And we oftentimes will give hair care products out. Well, a lot of hair care products don't necessarily translate to Black hair. So even things like that, thinking about having like small hair care products that will resonate and that will actually work for Black hair. If you do work in the jails, jail advocacy, the same type of thing. A lot of the clients that I've had, that I have now, that I've had in the past, have continuously brought that type of thing up, that, even in commissary, the materials, the types of things that they're able to get, it doesn't work for their hair. And so it's not even necessarily about just pushing the conversation in Congress, which is super important to Professor Green's point, but think about where those changes can show up, where they can resonate even within just the work that you're doing on a daily basis. Think about how you can affirm Black hair and Black women in their natural hair, and not in like a weird way. You don't necessarily need to go and be like, okay, I see you're wearing your hair natural today, but if there's a way that you can affirm and not potentially like say, if they're wearing their hair in a different manner, like, oh, your hair looks better that way, as the video stated. So those types of conversations are also helpful. And also, you know, we are several years into this pandemic at this point. And if a Black woman, for example, doesn't want to have her video on, or she doesn't, you know, and she's like, you know, I don't want to put my video on because quite frankly, I don't feel like doing my hair. Like that should be okay. And so there like has to be also creative ways to think about why someone may not want to show up in that moment. And sometimes it's related to hair. And so like creating an environment that will allow for people to have their hair however they want to, however they choose, is also, I think, a way to continue the conversations. And then again, to work with the folks who are doing it locally, right? Like most advocacy work, there's typically people who are organizing within your local communities, having conversations, working with them as well, and seeing what those conversations look like at a local level, so that you're ensuring that you're honoring the work that's already been done within that local community, and not necessarily trying to recreate a wheel, because these conversations are very important. And honestly, even if all you have time to do is just to share something on your social media about the Crown Act, or about the statistics, or about how this shows up, you know, that is even helpful, because any way that we can continue this conversation, keep this momentum, is what we need to be doing right now.
Right. And as an ending note, what advice might you give Black people about embracing the culture in a world where they've been told or forced to suppress their cultural expression? So what would you tell those people? And Professor Green, you can start, and then follow with Aubrey.
I say free the hair. Just do it. Just do it. And, you know, and one of the things that through the advocacy work that I've been doing is really to try to ensure that everyone, regardless of how they decide to wear their hair, is not, of course, obviously we are celebrating natural hair, but and natural hairstyles, but really people should have the freedom and the autonomy and the agency to wear their hair however they so choose, and according to their personal needs and desires, and whether that's rocking it straight, whether it's rocking it in Bantu knots or twists or locks or braids, that all of this hair diversity should be respected and affirmed, and not denigrated or stigmatized as a bad hair, or stigmatized as or privileged as being good hair. And that frankly, that we can all come to a point that we can really declare that all hair is good hair. So I am all for, you know, being able to, you know, if it's about embracing your cultural identity, do it. And I hope that through these conversations, through the legislation and the legal reform, is that it's basically, hopefully, ensuring greater levels of protection and greater levels of recognition as it relates to when we do decide to do that, when we do make those choices to actually express our racial and cultural identities vis-a-vis our hair.
100% agree with that. And, you know, like, I think even about this conversation, to your point about like, what is bad hair, right? There's no such thing. But really to kind of put it even at like a higher level, right? Most things that Black people have are in many ways utilized in cultures that are not within the Black community. And so also to just remind ourselves, right, that this is something that we should be proud of, and that it's something that we should feel is distinct to us and that we should be embracing. Because a lot of times I feel that we feel like we have to, you know, as our moderator stated, suppress ourselves because we've been told, well, this isn't professional, this isn't this. And then someone else from a different community will come and do the exact same thing. And now it's considered professional. Now it's considered okay. But the more that we actually just embrace that for ourselves and not allow for everyone else in society to tell us, well, now this is professional. Well, now this is okay. If we embrace it, if we start to build that self-confidence within ourselves and within our communities. Because I think even though it is something that's internal, right, this is something that needs to be a community effort across the African diaspora of us building that confidence among one another to be like, yes, we affirm that our hair as it grows out of our head, our hair, however we want to wear it, is fine and it's great. And not only is it great, like that is the definition of like Black excellence, right? Of us being able to have a liberated space to be who we want to be and to wear our hair however we want to wear our hair as well, because it is one of the just most distinct ways for us to kind of demonstrate like this is who we are as a people, and we're not going anywhere, we're not changing for anybody, and we are going to be who we're going to be.
Yeah.
This is so great. This conversation. Wow, we could do this for hours. This is so great. So we have about 5 more minutes left in this webinar. I'm going to try to do 2 questions and then do a quick wrap up. Does that sound great? One of the questions from the audience is, what do you think this act will address the hair types and stereotypes of other races and gray hair as women age? Professor Green, do you think that the Crown's Act would do that?
Well, it is opening up the conversation around grooming and appearance discrimination more generally at the intersection of so many different protected classifications like age, disability, obviously just things that happened just a couple of nights ago are raising questions or conversations around disability as it relates to Jada Pinkett Smith having alopecia, right? So I think the Crown Act and other types of legal reforms and greater levels of awareness around these types of reforms are definitely opening up conversations around appearance and grooming codes discrimination and its harms. Now, the Crown Act specifically does not address discrimination on the basis, grooming codes discrimination on the basis of age or disability or sex, but it does again, help people to really understand that grooming and appearance norms do implicate our civil rights statutes that prohibit discrimination on other grounds like sexual orientation and gender identity, age, disability, religion, as well as national origin. So, that being said, hopefully it will change, again, those personal, those individual stereotypes and biases as it relates to certain appearances like gray hair or shortened hair for women, or baldness for women, as well as other types of appearance norms that oftentimes, unfortunately, result in discrimination and exclusion and stigmatization on the grounds of protected classifications under our civil rights laws.
Right. Okay. So unfortunately, I'm going to ask one question. So at this time, thank you for joining us for this free webinar. We would like to express our gratitude to this esteemed group of panelists. You are all doing such great critical work, and we thank you for taking time out of your very busy schedules to share your experiences. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you please consider joining and becoming an active member of the ABA. You may do so at mbar.org/CRSJ. So I wish everyone the best of luck, happy spring, and stay safe, everyone. Thank you.